Morning everyone, and welcome to this webinar titled Updates on Data Protection. My name is Amir Kousari. I'm a Senior Associate at Boyce Turner, working in the Commercial Technology Group, and I would like today to sort of focus on the data protection landscape after the transition period, so from the start of next year, see what that might look like, focusing in particular on the scenario where the United Kingdom does not negotiate and agree a deal with the EU. So we're going to look at how that particular scenario might impact international transfers, how it might impact this requirement under Article 27 of the GDPR to appoint a European representative. I'm going to look at those in turn. We have a chat functionality, so if you have any questions during the course of the webinar, feel free to submit them, and I'll try and field them as we go through. So, as you're all aware, 31st of January, the United Kingdom left the EU, and we entered into this transition period, which is due to expire at the end of this year. The purpose being to negotiate a deal with the EU on trade matters, including hopefully data protection. We are well into that transition period now, and the negotiations haven't gone smoothly, haven't gone well. They've been delayed by the coronavirus pandemic. So it's quite likely that we will leave without a deal being negotiated, unless, of course, there's a drastic change in the speed at which negotiations are happening, unless there's an extension of the current transition period, but there's no indication that there will be an extension. So it is a real possibility that the United Kingdom will leave without a deal. For the time being, though, transition, business as usual, will carry on as before. But in the event of a no deal, the United Kingdom will become a third country. And that will impact things like international transfers. As a UK organisation, you need to be aware of additional steps that are required to protect transfers to and from the United Kingdom. You also need to be aware of this requirement under Article 27 of the GDPR to appoint a European representative, and that will affect UK businesses selling to consumers, to individuals in the EEA. But it's just important to understand the intentions of the government after the transition period. How they're going to prepare us, how they can prepare UK data protection law for the change. And the intention is to incorporate GDPR into UK data protection law to sit alongside the Data Protection Act. So even though we've left the European Union, we potentially don't have a deal, the transition period comes to an end, the principles of GDPR will be retained and will become part of data protection law in the UK. So if we move now on to international transfers and consider how they will be impacted by a potential no-deal scenario, we look at international transfers in a little more detail. What is an international transfer? Well, by international we mean the transfer of personal data outside the EEA. It's also referred to as a restricted transfer. And the principle is that these kind of transfers can only be made if they're covered by either an adequacy decision, they're covered by appropriate safeguards, but if neither of those are available, then an exception under the law. Now, we've looked at the sort of international element, transfer outside of an EEA, outside of the EEA. The concept of transfer itself is quite important as well, because transfer occurs when the personal data is transferred or made accessible to a receiver outside of the EEA. So there is a transfer in that you're sending it, say by electronic communications to them, or it's made accessible, in which case you can have a situation where the data sits on servers in the UK, but access is granted to an organization outside of the EEA. And another key aspect of it is that the receiver is a separate organization, so they're not part of your organization, they are a separate organization themselves. So that's the general principle behind international transfers and the restrictions. It's useful to know that transfers from the UK to the EEA will be permitted. So that's the intention of the UK government. They stated that those transfers will be permitted after the transition period. So you won't need to take any additional measures to safeguard the flow of data from the UK to the EEA. That position will be subject to review. So good to begin with, kept under review by the government and updated as we go on. But if the transfer needs to be protected in some way, one method is you can seek to rely on an adequacy decision. And if we're looking at transfers from the EEA to the UK, the problem with the adequacy decision in a no-deal scenario is you won't be able to rely on one, simply put, because we haven't got a deal. We've left, transition period has expired. The UK is a third country. No adequacy decision is going to apply. At that stage, there might be negotiations to try and achieve adequacy. And it might be forthcoming, given that the intention is to incorporate GDPR into UK data protection law. But when the transition period ends, there won't be an adequacy decision. But if you're looking at transfers from the UK, the sort of mood is slightly different. Because the United Kingdom has said they will be looking to recognise the current adequacy decisions of the EU. So there are currently adequacy decisions, some partial findings of adequacy, some full findings of adequacy in respect of the countries, some of which the United States, Canada, Japan, Switzerland, others include New Zealand. Those decisions will be recognised by the UK government after the transition period. So you can rely on those. If you're transferring to those countries, there'll be some measures in place already that you can rely on. If we focus on the United States as a specific example here, we've got the Privacy Shield scheme. If a UK organisation is looking to rely on that scheme to continue transfers of data to the United States, then the scheme itself will require some modification to enable UK organisations to do that. And the reason being is it's an EU-US specific arrangement. So it covers transfers of data from the EU to the US. And the UK is not part of the EU. What we're saying in this scenario is there's no deal, so we won't benefit from that arrangement. To continue with those transfers, what US organisations need to do is to update their public commitments to specifically cover personal data received from the UK. So they will need to take some steps, update their privacy policy to specifically cover these kind of data flows. And there is guidance on the Privacy Shield sort of website. The frequently asked questions sections include standard form wording for US participants to include in their privacy statements. to enable this to continue receiving data from UK organisations. But as an organisation in the UK, what you need to do is to check that the US organisation or counterpart has made this update. They've updated their public commitment, so you can continue to transfer data to them. And the easiest way to do that is to check their publicly available documents. So a privacy policy should contain that information. Moving on from the adequacy decision. So if adequacy is not available to sort of protect personal data flows, another method, appropriate safeguard, is standard contractual clauses. And this is a very convenient method of safeguarding personal data. There are standard model clauses which have been approved by the European Union, and these are simply downloaded, populated without amendment. Whilst they are a convenient method, the future of the use of clauses is somewhat uncertain at the moment, and that is primarily because of this case going through the Irish courts, which is brought by the privacy activist Maximilian Schrems, challenging Facebook's processing of data and sending that data particularly to the US. In December, the Advocate General in that case was referred to the European courts for comment and for decision. The Advocate General determined in December that standard contractual clauses are still lawful. They're still a lawful mechanism for safeguarding personal data transferred to third countries. But there were some concerns raised about their use, particularly in respect of transfers to a destination country where the law of that destination country conflicts with the terms of the standard contractual clauses themselves. So there might be some conflict. You might not be able to comply with the provisions of the standard contractual clauses. The obligation then is on the controller making the transfer to either suspend or prohibit that transfer. So you, in some respects, as a controller, you need to be aware, alive to the laws of the destination country that you're transferring the data to, just to ensure that there aren't any conflicts that might prevent the rights of data subjects from being enforced, and also from the provisions of European data protection law being complied with. Now, we must point out the Advocate General's opinion is non-binding, but what the European Court tends to do is that it follows those opinions. There is scope for derogation, so if they decided to either move away in part or in whole from the Advocate General's opinion, they can do so. But the general way things work is that they tend to follow the Advocate General's opinion, and we'll wait to find out which way the European Court goes here. And it could be quite important, particularly when we're looking at a post-transition period where we don't have a deal with the EU, and we might need to there might need to be safeguards to protect flows of data from the EU to us. If we also consider the flows of data from the UK to other countries, so not just to countries in the EU and the EEA, to other countries where we don't have an adequacy decision, for example, and we said the UK government intends to incorporate GDPR into UK data protection law, and that means that the rule on international transfers will apply in the UK. So if you're a UK organisation wanting to make an international transfer, you'd still have to comply with either the requirements of an adequacy decision or having some appropriate safeguards. standard contractual clauses would likely be an alternative for UK organisations, and the government has said that they intend to recognise standard contractual clauses as an appropriate safeguard. But again, we'll have to wait and see how the European Court will deal with the question marks around standard contractual clauses. An alternative method to safeguarding the flow of data, binding corporate rules, not a very common method used simply because it takes such a long time to have them approved, typically 12 months. And they apply to sort of multinational groups with entities in different countries, some in the EU, some outside the EU. And what you want to do is harmonize the flow of data between those group organizations, and you do that in the form of binding corporate rules. And even though it's not a common method used by organizations, if a particular organization is looking to go down this route, a no-deal scenario could impact how binding corporate rules are used, particularly the impact on current applications and future applications will be noticeable. Again, in a no-deal scenario, the ICO will be the supervisory authority in the UK, but it won't have standing in the EU. So if you're an organisation that's looking to go down the route of binding corporate rules, you will need to identify another lead authority to actually submit that application and take that application forward. So you wouldn't be able to use the ICO. If you're in the process of having an application reviewed and approved, so you've already submitted an application, then the ICO is identified as a lead authority. You need to identify a new lead authority, and after the transition period, it's likely that that authority may want to initiate a new process, which would cause further delays, which kind of makes binding corporate rules less attractive, even more so than they are now. So we've examined adequacy decisions, we've looked at appropriate safeguards. If none of those are available, then there are some exceptions which you could rely on to still make the restricted transfer, so international transfer. So, and I've set out a few here in the slide. This isn't an exhaustive list. This is just some of the main exceptions which are sort of likely to apply. This is where you have the consent. One is where you have the consent of the data subject, explicit consent, where the transfer is necessary to perform a contract with a data subject. You have a contract in place with them and you need to perform the obligations, and to do that, you have to make the transfer. There might be important reasons of public interest. So there's another interest in the background which requires you to make that transfer. Or you're doing that to protect the vital interests of the data subject. Or there's some other compelling legitimate interest, your legitimate interest, which means that the transfer can be made. But it's important to note these exceptions are only for occasional specific transfers. They shouldn't be used for repetitive transfers. So you may rely on them, but the scope is quite narrow. And again, so this would apply to UK organisations wanting to make international transfers, say outside of the EEA, to the countries where there's no adequacy decision, where appropriate safeguards are not available. Likewise, with our European counterparts, if they want to transfer data to UK organisations and they can't rely on adequacy, and they can't rely on an appropriate safeguard, these may be used to legitimise occasional specific transfers. Okay, so that is the international transfers element of this webinar. We'll move on to the European representative requirement on the European representative. So, if you have any questions, feel free to post them in the chat. and I'll try to pick them up as we go through. So, Article 27 GDPR, the European representative requirement. What you need to be alive to here as a UK organisation is, if you don't have an establishment in the EEA, but you either offer goods, services to individuals, to consumers in the EEA, or you monitor their behaviour, then you would need to appoint a European representative. And this is going to be quite key, because if you've got an operation in the UK and you're based in the UK only, then it's quite clear that after the transition period, you're not going to be established in the EEA. So you need to be alive to this, and you need to be sort of taking measures, making those inquiries and seeing about your own business model, seeing if you fall into this category. This is something to make sure you comply with. There are some exceptions. Public authorities don't need to be concerned with appointing a European representative. Also, if you're processing activities are sort of occasional, they're not large volumes, they're not repetitive, they're very low risk, they don't involve special category of data, then you don't need to be concerned with this European representative. And just going back to the initial points there, we're focusing on sales of goods and services to individuals, so not businesses. If you're monitoring their behavior as well, and if they're in the EEA. So these are key elements of it. Also important to note, you don't need to be concerned with appointing a representative during the transition period. So this will apply after the transition period. At roles and responsibilities, there are some responsibilities prescribed in the GDPR itself. Under Article 30, the representative needs to maintain a record of processing activities under its responsibility. So what does this entail? Well, you as a business might have a number of different processing activities. You might be processing the data of individuals in different scenarios. You might appoint a representative in respect of specific activities. And what this is going to require, thinking practically, so the representative is almost certainly going to need to do some sort of audit or due diligence on the organisation making the appointment, just so they're familiar with those activities and they're comfortable with them, and they are fully able to maintain these records and comply with this requirement. So, you know, there'll be a little process before. Another responsibility, another requirement under GDPR comes into play under Article 31 and 58, and this is a requirement for the representative to cooperate with and provide information to supervisory authority when they're performing their tasks. So, typical task of a supervisory authority, investigating complaints, data protection breaches, things of that nature. If that comes within the ambit of the responsibility of the European representative, then the supervisory authority would be able to go to that representative and ask them for information, and the representative will need to provide that information. And these are the responsibilities under the GDPR. The European Data Protection Board has issued some guidance on European representatives and the scope of their responsibilities and liabilities. What they have stated is that representatives may find them in a situation where a sort of process, fines, issuing fines, penalties, is initiated against them by a supervisory authority. So the supervisory authority can initiate that process against the representative, but ultimate responsibility for compliance lies with the organisation making the appointment. You as the organisation, if you're required to make this appointment, you don't pass the buck for compliance to the representative, you remain responsible. The representative is effectively acting as a liaison with that supervisory authority, unless they've failed to maintain adequate records of the processing activities, have failed to provide information to supervisory authorities, it's difficult to see how they will be directly liable for the breach of the organisation that's making the appointment. So that's the final bullet point there. Okay. If we look at the appointment in more detail, what you would need to do to actually make that appointment. Well, the appointment needs to be in writing. So you need some sort of written mandate. The example given by the ICO is a supply of service agreement, so that should be sufficient. It doesn't need to be overly complicated. The thing to consider is where the representative will be located. So the representative needs to be located in a relevant member state. What do I mean by that? Well, if you're processing data of individuals, so you're selling goods, services to individuals in, say, France and Germany, then you will need to appoint a representative in either France or Germany. You wouldn't, for example, be able to appoint a representative in Italy. And it's important that you make the details of the representative easily accessible to the public and also to the supervisory authorities. So both data subjects and the supervisory authorities concerned know how to contact the representative, know the identity, know the details. Publishing them on a privacy policy, publishing them on the website are obvious methods to comply with that requirement. So, we've looked at international transfers, how they will be impacted by a no-deal scenario, and also how this European representative requirement comes in the event of a no-deal scenario. What can you do to prepare yourselves? Well, just to sort of recap, really, international transfers, what you need to do is identify international personal data flows. So where does your organization send data? Just be clear in your minds. If you're responsible for identifying those data, make sure that you have done so correctly. You know where that data is ending up, which countries it's going to. Then, once you've done that, you can check whether any additional steps are needed to ensure that transfer can continue. So we've said that after the transition period, the flow of data from the UK to the EEA will be able to continue without restriction. That's the intention of the UK government, to allow those transfers. So you won't need to take additional steps there. If the data is coming from the EEA to the UK, in a no-deal scenario, you will need to take additional steps. And also, you'll need to update the relevant documents where this is necessary. So you've identified international transfers, you've taken additional measures to safeguard those transfers. You need to then reflect those changes in your relevant documents. So your privacy notices, privacy policies, data protection impact statements, they will need to be updated to reflect these changes. In terms of the European representative, how do you prepare yourself? Well, you need to assess whether the requirements apply to you. Understand your business model. If you're selling to individuals in the EEA, if you're monitoring their behavior in some way, that's your business. Then if you don't have an establishment in the EEA, unless you'll benefit from an exception, you will be required to appoint a representative. And then you will need to decide, once you've decided that you need to appoint a representative, you will need to decide where that representative will be based. So where would be the best location for your business? And you need to then put in place an appropriate written mandate. So that mandate, before you actually put it in place, before you agree those terms, it's likely that you're going to need to do some sort of preparation. The representative is almost certainly going to need to do some preparation and and checks on your activities. So you need to build in some time for this process. And finally, you just need to update, again, documentation. So privacy policies, websites, those will need to be updated. Just moving on slightly now to other aspects of GDPR, GDPR, of European data protection law, which has made its way into UK law. PECA is one of those, privacy and electronic communications regulations. It's a set of regulations which are going to apply after the transition period, and a lot of people have sort of overlooked some of the updates which have been issued by the ICO in this respect. These updates issued in July of last year in respect of cookies. So we've sort of talked about international transfers, we've talked about European representative appointment. There are other aspects which are going to continue post the transition period, and as organizations you need to be alive to these, even though they've sort of been implemented a little while ago. So these guidance in particular, coming into effect in July of last year, changed the way users of websites and applications interact with cookies. And cookies, a distinction being made by the ICO between essential cookies and non-essential cookies. So essential cookies, we say any kind of cookies which are required, or they're strictly necessary for the operation of a website or an application. So things like analytical cookies, they are not deemed to be necessary, strictly necessary. So what you can do as an operator of a website, of an application that uses cookies, is to use strictly necessary cookies without the consent of the user. What you can't do is use any non-essential cookies without consent. All other cookies, they require user consent. And what does consent mean? Well, consent, the standard of consent, is now aligned with GDPR, so it needs to be freely given. It needs to be specific, informed, and unambiguous. This is now quite a high standard, as we're all aware. And what this means in practice is that if I go onto a website that uses cookies and I'm greeted by a splash page, typical pop-up, which notifies me that cookies are being used by the website, the cookie settings on that website need to be updated so that only essential cookies are enabled. Strictly necessary cookies, they're enabled. All other cookies are disabled. And it will be for me as a user to enable those settings before they can be active. That would be consent. Likewise, if I go on to a website and again I'm greeted by the splash page, the message on that splash page can't be such that my continued use of the website will be deemed consent to the use of cookies, because that does not satisfy the threshold for consent. So if you've not updated websites, if you've got applications, if you've not updated them, the cookie settings on them, please do so This guidance is now in effect for almost a year, and what's clear is that users are becoming more alert to their rights and to the requirements of cookies, and they are quite capable very easily to submit complaints where they find that an organization is not complying with the requirements of the cookie consents. They can submit complaints to the ICO for the ICO to investigate. And there has been a spike in the number of complaints submitted to the ICO. If we look at the number of complaints submitted in the final quarter of last year, there were somewhere around 350 number of complaints. And if we compare that to the number of complaints in the first quarter of this year, we'll see that it has gone up by some 350%. It's around about over 1,000 complaints. Now, there is a bit of a backlog. The ICO has not investigated every one of these, but you don't want to be in a situation where your organization receives a knock on the door from the ICO asking for explanations as to why your websites or applications haven't been updated. So, it's easy to focus on other prevalent issues like international transfers, European representatives, when the transition period expires, but this is something just to be alive to as well, and just to make sure that you have updated your websites. So that's sort of the end of the presentation part of the webinar. Any sort of questions? I can see one question on the chat function. And what does, so we've got a question here from Shirley McCulloch. What does monitor behavior mean in the context of Article 27? Well, monitoring behavior, effectively, if you're doing any kind of analytics work involving individuals in the EEA, typically data analytics is one of those examples of monitoring behavior. If you are doing that, then that would bring you within the concepts of this European representative. So if you have any further questions on the subject of the webinar, feel free to either submit them on the chat, or if you would like to contact me, feel free to email me. My email details are up there on the screen. I'm happy to sort of come back to you with an answer.